Ladies and gentlemen, so as I was saying, the reason we're calling this records access cases is, although the district does use Freedom of Information Act in line with the federal Freedom of Information Act, not every state or jurisdiction or territory does. So a former colleague in our office decided that it made more sense to refer to the cases that we'll be looking at and discussing today as records access cases. So that's what we're talking about today. We are, contemplating FOIA and the ability to access records in a FOIA, Sunshine Act, records access, et cetera, manner. But the reason we call it records access cases is we are going to look at district material. We are going to look at District of DC, extra jurisdictional cases, as well as things in territories and other locations. So we just went with records access cases, but it is part of the FOIA webinar series, and you are in the right place if you are a FOIA officer or a DC government attorney. So while we're waiting to resolve our recording issue, again, second to last in our FOIA webinar series, we will be joined next week by two attorneys from the Office of the Attorney General, discussing preparing for and dealing with defensive FOIA litigation, preparing for FOIA litigation and handling litigation. This was last year one of our most popular presentations, and I expect that it will be again final in our series next week on the 13th. So getting our technical challenge resolved.
Okay, Attorney Scerbo, we are recording, so please.
Fantastic. Proceed. Great. Thank you very much, Director. Okay, so to resume, we are going to move forward. I'm not now advancing my slides. Let's see. Here we go. So the first one we're going to talk about is procedure. There are, two tracks within our statute. You can either go the administrative approach or you can follow the judicial track. Obviously, the administrative track is probably the one that 9 out of 10 cases follow, most FOIA officers deal with, which are administrative appeals to the MOLC, Mayor's Office of Legal Counsel. Those procedural rules are located at under the regs at 1 DCMR section 412. There are a lot of reasons why 9 out of 10, and that's just my estimate off the cuff, but I'm pretty sure I'm right if it's not, why the administrative track is the more popular and the more common. First is it's much cheaper. There's not the filing fee, et cetera, et cetera. It's much less complicated. The instructions are right there on the web page. And the procedural rules are fairly simple. Generally speaking, the timelines are tight. Once the appeal is filed by the requester, the agency has 5 business days to respond to the MOLC, to make their case or to make our case, depending on who it is. And then within 10 business days, the MOLC has to, come to its disposition. That's very appealing for all those reasons to a requester. And obviously then Superior Court is still available to a requester if they're not able to, get satisfaction. The other approach obviously is directly to the Superior Court, which they can do. Here got listed, the link to the PDF for the case management plan for the process for Superior Court. Obviously here we're talking about, not only are you talking about the filing fee, but you're talking about the calendar, which as of last year at least, you're talking 2+ years. And unlike criminal, there is no right to a speedy trial, there is no right to appointed counsel, et cetera. The main advantage that Superior has as a process, and it's not always opted for, but sometimes it is recommended or compelled by the court, is that, you do have what is called, and many of you are familiar with, multi-dispute resolution, which is mediation, which has many benefits and advantages, not the least which is that the court, the volunteer mediator maintains confidentiality on the process. So there is that. But generally speaking, most people will follow for budgetary, time, et cetera, reasons. So just this a little bit, moving along to how you find the law. Now, unfortunately, in terms of researching the administrative law on FOIA appeals, records access appeals, and law in the district, it is not easy. Lexis, for example, only goes back to 1998. MOLC opinions, the Mayor's Office of Legal Counsel opinions, are published in the DC Register. Some can also be found online, but it's very hit and miss. And unfortunately, MOLC only became the trier of fact, if you will, in 2015. Before that, it was the Secretary's office, and before that, it alternated between a number of agencies. So it has not always been the MOLC. So depending on the age of what you're looking for, you may not be searching for MOLC. You may be searching for a different office. But your best bet to start with is to search the register. Here again, you've got, an example, for example, searching Freedom of Information Act appeal or FOIA appeal, and then this is just an example, and then exempt with the wild card, and then 2534 or 204. Again, you structure your string based on what it is specifically that you're looking for, very similar under Westlaw. There are, under DC regs or the DC Register archives, which go back from 2003 to 2009, and then obviously DC regs from now to the present. I don't know how many of you, but I know I go crazy searching on DC regs, and I get calls from constituents and others frequently who are having great difficulty searching it. But you can go in and you can find Freedom of Information Act, FOIA appeal decisions in thing. And then the other thing, if you're really looking for something older, go to MLK's fourth floor into the Washingtoniana collection, and you can actually look at the start of each year's register under FOIA appeals, Freedom of Information Act appeals, et cetera. The terms don't always follow consistently from year to year, but you generally can find it at the beginning of each register's index. All right, so this is what I was alluding to at the beginning. When you're looking at and searching all states and territories, the records access opinions, this search, which again, a former colleague created, this is going to give you all 50 states plus the territories, et cetera, all the different short titles. So you've got FOIA or public records or sunshine or open records or right to know or records access or government access and data practices. This search string in either Westlaw or Lexis is excellent in terms of getting you what you need to know if you're doing a comprehensive search. I recommend it, and again, this deck will be available after the presentation, but I strongly recommend. I've used this and tip to Nick Weil, our former trial attorney. Now we're going to talk about some specific appellate opinions relevant. So when is legal boilerplate okay? And then, but not, the syntax of a question. So in Chicago Justice Project versus the district, what you had was a long legalistic FOIA request. It's an unpublished order, but it is available at Superior and within the portal. It's, free search. The request required a FOIA officer to perform a very laborious legal analysis. I'm going to show you that in a moment. But, the court eventually remanded and required MPD to finish searching for records on their gang tracking database. So, here is the 2 pages of this search, and from the beginning, the request included definitions, which the court said were good and valid and assisted in the process. But they said, this is what we mean by records or documents. This is what we mean by a database and gang affiliation and access. And then they gave instructions all the way down. And you can see, and I apologize, it's not the clearest scan of the document. And then it asked for as much detail as possible where a document's not provided, et cetera. And MPD balked and did not, did not, on the basis of the fact that it said that you're requiring us to perform, legal analysis, but it did, the court ultimately did say, in terms of their request number C2, please provide records sufficient to show each public or private entity, whether on the federal, state, or local level, that can view or otherwise has access to the data within each database detailed in request A1. And going back to A1, looking for non-privileged data, et cetera, and the court said this is fine. This is a valid request. In fact, it's a well-phrased request. It's a very helpful and useful request, and so they did remand. Now, I said before, compare this with this case in Ray Rose, where there was a simple request made, but it was a request a few years ago on something that had to do back during the World War. And the requester said, you state that the MPD denied your request for the following records. They were looking to deal with whether, the police investigating communist activity in Brazil is said to have had contact with the police in DC sometime between 33 and 39. And the person in question was Captain, and I'm not going to include the name, but it was a revolutionary figure at the time. And they said, do you have any records of communication with this Brazilian officer? And MPD, responded and sent a letter acknowledging, and it said, we can perform the search, and it advised its fee schedule. And then the individual, the requester, replied back, well, I'm willing to pay. I don't need all that. I just need anything more than a simple yes or no plus the date, if was asked to have some kind of contact with the police in this time frame. It'd be nice to get this other information. I don't need copies of any documents. At that point, with this clarification, MPD determined that it was, DC FOIA not requiring agencies to perform research, analyze data, answer written questions, or create records in order to respond to a request. So because there had been a question mark in the initial request, back here, remember, do you have any records of communication? And even though MPD then responded and provided a fee schedule, the fact that this person then provided clarification, MPD then denied. Well, the MOLC turned around and said, we agree. It's not obligated to create records for you, and it does not require MPD to perform legal research. Now, that strikes some folks as funny that the request was not initially denied on the basis of the syntax with the question mark, but later, but nevertheless, the MOLC, came to this conclusion at this point, and that was their determination. Talking about GLOMAR. For those not familiar, GLOMAR is a federal FOIA doctrine. People ask whether or not district jurisprudence on FOIA involves GLOMAR doctrine. Now, GLOMAR was a ship, the GLOMAR Explorer. In the early 70s, I believe, a Russian vessel sank, and there was a pretextual operation conducted by U.S. intelligence with the vessel called GLOMAR Explorer, and an investigative journalist caught wind of this and wanted information. Now, this is where we get the famous phrase, we can neither confirm nor deny the existence of, is from the GLOMAR opinion. And essentially what happened was, we can look at sorry, I'm looking at my notes to make sure. The requester filed a FOIA request. The government did not want to reveal anything and said that whatever we do, whether we say yes or no, providing responsive records with redactions, what we're doing is we're violating national security by even acknowledging the existence of this. We are providing information that is classified. And the court eventually said yes. A GLOMAR, what is now known as a GLOMAR response, is in fact valid and be invoked in the case of these situations. What you will not find is phrase GLOMAR or GLOMAR doctrine in Superior Court or Court of Appeals here, or most of the state's courts, frankly. But the MOLC has occasionally dealt with it. And these are two cases, Hannigan and Zangari, where, for example, an employee being investigated for misconduct, the fact that you even acknowledge or provide redacted documents, for example, would potentially implicate the fact that there was an investigation of an employee. So, bear in mind, GLOMAR as a concept does exist in the district. It may not be referred to as GLOMAR, it may not exist as GLOMAR per se, but it is out there, and it is at least in a few MOLC opinions. But conceptually, you may find it, but you're going to have to use keywords and head notes as opposed to looking for GLOMAR specifically, which at the federal level is much easier because GLOMAR doctrine is invoked a great deal of the time. Talking about public interest versus privacy interests. We got a couple of the MOLC cases here, including Zavala. In Zavala, the court affirmed the exercise of Exemption 2 because essentially, there was no, in the balancing test, there was no adequate public interest demonstrated with respect to a party's to their Uber receipts. And it was clear to the court that this is a bridge too far. With Isfino, same thing. They affirmed the exercise of Exemption 2 because, again, victim impact statements, which many of you who've done criminal or what have you are aware of, the public does not need to know the information in the case that was brought in as Isfino. The court determined the information in here is subject to Exemption 2 and is balancing test does not support a release of the information because there is no public interest that outweighs the privacy. And then in Pearson, which we'll see again and again, this concept, there is a public interest associated with the resume and application of a successful candidate for a government position that outweighs the applicable privacy interest. And usually in the district, at least what we see is the higher the office or the higher the position and the success of the applicant, the more likely that the balancing test is going to weigh public interest versus privacy. And conversely, the lower the position, and certainly where their candidate is unsuccessful, then the balancing test is going to favor privacy over public interest. So in Winters, what we had was a situation, many of you who've done federal know, there is in fact, the Federal Privacy Act of 1974. DC does not have a comparable statute to the Privacy Act. If you want your own federal records, there's a well-trod path on how you request them and get them more easily than on another type of record for yourself. But in the district, it's less clear. It's doable. There are processes, but again, there's no statute that guides you. But in the case of Winters, the MOLC chastised MPD where the requester sought his own records, and MPD did not verify the identity of the requester who sought, in this case, all public records from 2006 to 2019, which refer to reference, remark about, and/or comment on this individual. I'm not going to say their proper first name, Winters, or any aliases with the proper last four of their social, and their proper place of birth. And MPD just summarily denied pursuant to Exemption 2 on privacy and said, clearly this would be an unwarranted invasion of privacy. And the MOLC said, they remanded and said, you should have verified the identity, because if you had verified that this was in fact the individual requesting their own records, it would have negated the privacy interest objection. So, this was what a colleague once called a warning shot, that is essentially, you cannot just arbitrarily or knee-jerk react and say, oh, there's probably potentially privacy interest, and even though it's you asking about your own records, we're just going to deny it, because that's not probably going to fly in either track, administrative or judicial. Some other court cases that we've seen in Kane, the ANC can't be sued in its own right. Generally the plaintiff has to sue the district at large. Gooch, even though the federal jurisdiction is narrow, one way to get access to federal courts is through pendant or supplemental jurisdiction. People often ask, can I get to a DC FOIA case through a federal court? And you could try by attaching a DC claim to your federal claim. Gooch was a prisoner dealing with a habeas action, and he also, to prepare for his habeas action, sought records from MPD. Unfortunately, he didn't append it to, he didn't append a federal action. He just filed his FOIA request in the federal court. Instead of having he was doing his research and wanted to do his FOIA case. Instead of having his habeas action or in a federal cause of action, which he then could append his thing to, he just filed. The district court dismissed it because you're in the wrong court. And the case has been refiled and it's currently in process. But the original, there was a case a few years ago that was never heard on the merits. Similar, it was a 14th Amendment violation on due process and equal protection rights regarding a FOIA request. And they did hang a pendant DC FOIA claim on it. But again, it was dismissed on its merits, not on the relevant material facts of the FOIA case. But, we would have seen at that point the process go through on hanging a district FOIA case on a federal action. Some additional extrajurisdictional cases, U.S. right to know. This is how Vermont and DC differ, and you can find numerous situations where states or different jurisdictions differ in their definition of a public record or a document. We're going to talk about something funny here in a moment or two in terms of defining records or public records. In Summers, in Ohio, third party of the requested information did not moot the action. In Farley, the statute provided for damages for the violation, but unfortunately, the plaintiff needed to send, according to the Ohio statute, they needed to have sent the request by certified mail, registered mail, Federal Express, something like that. And they didn't. They didn't send it in a way that could be tracked. And so unfortunately, they couldn't support their claim. But the statute did provide for damages of the violation of the records access. In Eddington, the district court held that there is no mailbox rule for emailed FOIA requests, unfortunately. According to the plaintiff, they said, I sent this, I filed an affidavit. The email stamp proves I sent this at this time. And the court said, there's no indicia of reliability in an email, unfortunately, unlike the Postal Service, which I think many would find amusing. we don't have the ability to this, so there is no mailbox rule applicability or relevancy for emailed FOIA requests. I don't know that everybody would agree with that holding, but there it is, and it was in 22. And then down in Texas Court of Appeals, you have Lamb, where the court held that presidential electors, the people that go to the electoral college, are not a government body in terms of the state's FOIA, or in that case, public information, sunshine, right to know statute. So even though they travel on government funds, even though they go to the state capitol to conduct government business, et cetera, that's not enough, according to that court, to make them subject to the statute. In State versus Webb, this was going back 25 years or so. Case was decided in 2001, a couple of years afterwards. This was a misdemeanor violation of the state's public record statute. But in this case, the member of the board not only had to pay a $1,000 fine, which was not unprecedented. They had had members who had lost their positions or been suspended, and they'd had large fines assessed against the members. But this individual also spent 7 days in the pokey in jail, which was a first for Florida. They had never had that before. So it is possible in certain jurisdictions, under certain sets of facts, for an individual to go to jail over FOIA violations. And people never believe me when I tell them that. Talking about, again, campaign for accountability. This is a reading room issue. Again, this is a deep fact pattern. But essentially what this comes down to is whether or not providing the records into a reading room, posting them on a website, is sufficient and meets the requirement for fulfilling a requester's FOIA request or not. And in this case, the court said no. Putting them on a reading room is not the same as fulfilling the FOIA request of the specific requester. Talking about procedural issues. Scerbo versus CIA. This is one of the reasonable minds can disagree. Scerbo was filing with various intelligence agencies about mind control, mind manipulation programs, mind reading, et cetera. And the courts essentially held that, you've not identified anything specific to make a FOIA request about, any specific records to state a plausible claim. And so they held that, the agencies, in this case, the CIA, they found for the CIA and said that you don't need to, you're right in your denial. In ULIS versus FBI, ULIS, those who are old enough or those who are history buffs, there was an individual in the early 70s who stole a lot of money and boarded a plane. I believe he ordered a bourbon and soda. And then at some point or other, may have exited the plane and disappeared into the annals of history. His name was D.B. Cooper. And, great unsolved mystery of our age. And Mr. Ulis was seeking a record from the FBI. And specifically, what he was seeking was D.B. Cooper's clip-on tie, necktie. And he was calling that a record. And the agency essentially said, as defendants point out in their motion to dismiss for failure to state a claim, he's not seeking anything that could even arguably be considered an agency record. Instead, he seeks a clip-on necktie. Of course, Mr. Ulis does not seek any old tie, but specifically the tie of the infamous D.B. Cooper. They did not find for Mr. Ulis, they found for the Bureau. And then in Institute for Energy Research versus Federal Energy Regulatory, they were seeking records on the calendar Federal Energy Regulatory Commission, and essentially they were denied everything except that the agency itself and the courts agreed that they had incorrectly misclassified essentially calendar entry on a lunch with a lobbyist that the director had had. But everything else in terms of receipts and et cetera, the court held for the agency. Okay, so now we're talking about agency control. Excuse me. In Behar, this was about the transition teams coming out of the 2020 election. Journalists submitted 3 FOIA requests on the transition teams, on both the president and vice president. The GSA produced several hundred pages of documents, and it had salaries and job titles. And at the lower end of things, and this gets back to a principle I talked about before, the GSA redacted several low-level team members' names, and it invoked, federal FOIA Exemption 6, which protects personnel and medical files, on clearly unwarranted invasion of personal privacy. And the district court and the Second Circuit both held that that is correct, and said there is no public interest in these lower-level employees' privacy being invaded. In terms of record creation, you have ACLU Immigrant Growth Project versus ICE. This one gets more complicated. This has to do with databases. Again, I'm not going to beat this up too terribly. It is interesting, and I would suggest that for those who are looking at either how records are classified, stored, produced, the key issue here, and I'm going to read from this, because it talks about creation of record or not a creation of record. So, the ACLU requested that ICE produce records to the 5 stages of immigration enforcement and deportation, and it had anonymized unique identifiers for individuals. So what ACLU wanted to do was track each individual across all the data. And ICE produced most of the requested information, but didn't comply with the request to provide anonymized unique identifiers. So basically, John Doe would be A5, and Jane Doe would be A6, and Tim Doe would be A7, et cetera. Because although ICE stores the immigration data by event, it can, and on that ad hoc basis does, access that information in a person-centric meaning about John Doe or Jane Doe. But the Second Circuit held that wherein ICE would query the databases for data points, using a query to search for and extract a particular arrangement or subset of data in an agency's database does not amount to the creation of a new record. So in this case, they said, this is not creating a new record. So again, if this touches upon something that your agency deals with or faces, I do urge you, not that it is primary, in our jurisdiction today, but again, the holding here is instructive. In Rudula versus DOT, the applicant was trying to be an air traffic controller with the FAA. He tried to apply the facts from the prior case, the American Civil Liberties Union and ICE. In this case, however, he sought information that the FAA didn't maintain in any format, essentially. He wouldn't just require them to produce information they retain and use in a slightly altered format. It would have instead required the FAA to produce a whole new record, screenshots of information that it doesn't store. And the court, in this case, the Fifth Circuit, said FOIA imposes no such obligation on an agency or agencies. So there was great clarity from the Fifth Circuit on that one, that there is absolutely no requirement to produce, new data. Talking about, foreseeable harm. This is the James Madison Project, which is a libertarian outfit, versus the Office of the Director of National Intelligence. This case is about what's known as Havana syndrome, folks who work in embassies, intelligence agencies, who are dealing with physiological problems, possibly from exposure to high energy weapons, directed energy weapons, sounds, et cetera. And up to this point, when this decision came out, and the case is still ongoing, but when this opinion came out, the court said essentially that FOIA is not a cudgel, quote unquote, to force disclosure of sensitive national security information. So, despite the fact that, people are interested or people have a need or desire to know, that you can't use FOIA as a blunt force weapon to compel sensitive or in this case, sensitive national security information. Talking about exemption 4, talking about commercial. True case is about executions and the drugs, the cocktails, the compounds used in executions. This talks about in the records when, and I'm going to quote, when identical information appears in a reasonably segregable portion of a withheld record, the government must release the public portions of the document with redactions. And against this muddied backdrop, the court will order the department to produce for in-camera review the 16 challenge records without redactions, along with 5 publicly disclosed records for comparison. So again, you can't just, you can't just assume that things are not segregable. You have to, in fact, make the case and expect that the court will, in fact, review in camera and make a determination. AMA systems, I don't think there's a huge amount there. Yeah, that was a fairly minor trade secret case. American oversight, kind of the same thing. This had to do with the consultant corollary, for those who aren't familiar. This is a question of whether the information is covered if the document in question or the material that is having either the privilege or the exemption applied to it comes from inside or outside of the government. And in this case, it wasn't clear entirely whether it was from inside or from outside. But the problem for the court was that so much of the material was subject to exemption that what little there remained that was not either privileged or subject to exemption was so inextricably bound up with the rest that it was virtually impossible to make a determination. But the main question was, if it was someone who was within the government, it was it would go the one way and it would matter and apply. And if it was not someone, it would go the other way. Again, I suspect that there are agencies who are with us today and officers who are with us today for whom this is a very key question. And it is our district. It is, DC district. So again, I would recommend that you take a look at this case. It was only decided earlier this year, and it may be excuse me. In terms of deliberative process, essentially, Colorado Wild Public Lands is fairly easy. The plaintiff got everything it wanted. It was a mootness issue. U.S. Forest Service essentially gave, everything that they asked for, and yet the plaintiff still, in the words of the court, remain unsatisfied. In opposing the motion to dismiss, plaintiff first contends they failed to demonstrate that it fully satisfied. Next, it asserts the case remains live because the volunteer release of the records perpetuates their illegal pattern or practice of denying access until well after the administrative procedures close, and inadequately explaining the initial FOIA decisions when releasing records during litigation. Basically, the court said, you, the plaintiff, have trouble taking yes for an answer. And said you're essentially muddying up, you're using this pretextually, and this issue now moved. In Vanda, Vanda had said that requested documents didn't enjoy the deliberative process privilege because they weren't pre-decisional or deliberative, and that the FDA failed to meet the foreseeable harm requirement, and the FDA should disclose the requested documents regardless of whether deliberative process privilege applied. The court denied FDA's motion for summary judgment and granted for Vanda. They said that, you know, the foreseeable harm requirement was not met, and that mooted the issue of pre-decisional or deliberative privilege. And also they said that, you know, FDA should not reasonably expect their deliberations to be kept private, and reason that a disclosure cannot have a chilling effect, which was the FDA's argument in such a case. And also that the FDA had a public health argument, and the court found it to be based on essentially speculative harm, something that could happen rather than harm that would happen. And the federal statute requires that it's would, not could. So, you know, the court concluded that FDA failed to meet its reasonable harm or foreseeable harm requirement. Getting back to some important cases for DC in terms of the adequacy of search, and I wanted to sort of finish out with these to a degree, because, you know, these do apply. Doe versus MPD was the case that essentially endorsed the test employed by the federal courts for evaluating the adequacy of a search for documents responsive. FOP versus district, famously known as the Peaceaholics case, gets into and basically lays out the deliberative process privilege and the adequacy of search in the district. Everyone's least favorite case, at least for FOIA officers, FOP versus district 139 a third, because this is what is known as the no void for volume case. And as we've discussed in our previous webinars, DC does not have a void for volume provision in our statute. So unfortunately, this is where that was established or made clear to plaintiffs and requesters, as well as to the defendants. And then Leith is just a dictum case against MPD and the references here for you all. This gets us to essentially the end. I mentioned our former colleague who left us earlier this year, Nick Wild, who was our trial attorney. Nick very brilliantly came up with a case law standard for responsive adequacy that I think we all really like. Here in slide from Nick's presentation. First, he would show that your search was reasonably calculated to uncover all relevant documents, and follow any leads along the way that likely will yield, likely not might, yield more responsive records, and B, evaluate your search in hindsight as you go along and don't just stick to the initial provisional plan you might have had. So not only do you go with likely as you go along, but as you're going along, you also are thinking back to things you've done prior as you encounter new things and revise backwards what you've done as you go along. And then number two, be prepared to adequately explain, such as in an affidavit, both how the search was conducted and why it was conducted in that way. And his practice tip was, it'll be easier to support that with a contemporaneous record kept in a routine, consistent, organized way. So as you're searching, you write down, I searched this, and as I searched this, it occurred to me that. So therefore I went back and searched this again, or I searched this in addition. And if you do this consistently and keep a consistent search journal or consistent search log, it will be much easier for you to provide your affidavit or your statement to either the MOLC in your response on an appeal, which you have 5 business days, remember, to respond to, or if a case is filed in Superior, when you have to file your answer on an appeal filed at Superior. But this is great, and like I say, I keep this in my notebook because it's a terrific standard cobbled together, which to use. Ongoing, if you need any assistance with Open Meetings Act, which we police and sort of keep an eye on and enforce, or FOIA, which we do provide district agencies with guidance on at all times, please reach us here at 202-481-3411 or opengovoffice@dc.gov. This is us, and I'm joined by almost all the folks on this Director Allen, who you heard from earlier, the Director of Open Government, Chief Counsel Louis Neal, my colleague Brandon Lewis, another attorney advisor, and our head of IT, Kimberly Brown, our paralegal specialist, is off today, but she's also here, always assisting us in our work. So with that said, I would like to ask if we have any questions from anyone.
I do not see any questions in the chat.
Okay, well, I will stick around until we're out of folks who've left, and Ms. Condell.
Sorry,
has her hand raised.
Tanya Kondo said her hand is raised. Tanya, I'm not sure if you'll be able to
If you can't
verbally ask your
unmute.
question. So Tanya, if you could put it in the chat, I will repeat it for Mr. Scerbo. Thank you, Tanya. Okay, the question is there any guidance regarding individuals using FOIA to circumvent discovery?
So the short answer to that is yes. I cannot direct you immediately off the top of my head to either the dicta or to the opinion, but it has been held that discovery is discovery, and that using FOIA to substitute for proper discovery is not, it's either not adequate or it's not proper. And I can't remember which. Off the top of my head, Director Allen, jump in if you remember. But courts have said that it is not an adequate substitute, and that that if you are engaging in discovery, that is not to say that you can't use FOIA and provide documents provided for you as part of discovery, but that it is not a substitute, and that you can't use discovery compulsion to alter FOIA. FOIA's rules are FOIA, and the FOIA process is that, and discovery's rules are governed by the court, and never the twain shall meet. So,
And I'll just add to that, Tanya, if it's a case that's in active litigation, that would be something that the attorney who is litigating would address with the judge. So in that matter, if you have a case that you know is ongoing and one of the parties to the case is sending you a FOIA request, you need to make sure to address the issue with the attorney that is representing the district. And that person will deal with the requester and will give you specific guidance as to what you should do regarding that FOIA request. I do not see any other questions in the chat. Looking, so I think that's all, Attorney Scerbo.
okay, great. Well, thank you all for joining us today. As I said earlier, we will have the Attorney General's office in next week to talk about handling FOIA litigation and dealing with defensive FOIA litigation. It'll be a great presentation. We hope you join us. If you need to update your contact information or have additional FOIA questions, don't hesitate to reach out to us. We're always here. Somebody's always here. And we're happy to help. And like I say, I will stick on until the end if somebody has any questions and wants to reach out, or feel free to reach out anytime this afternoon. Other than that, have a great day, and thank you all for joining us.